The Nigerian judiciary has come a long way since the creation of the native courts in 1842 and the Supreme Court in 1900 by the British colonial administration. As an institution, the judiciary started as an instrument of consolidating and giving legitimacy to colonial rule. But at independence in 1960, the Nigerian judiciary attained the status of an independent arm of government. After independence and during the period of military rule, the judiciary was greatly tested and undermined by various decrees, tribunals, ouster clauses, intimidation of judges and underfunding. But this arm of government was resilient, producing some very courageous judges who gave very profound and landmark decisions which held the country together.
Well, there is a whole lot of them, starting from the Abraham Adesanya case versus the president that had to do with local standard. Of course, you remember the Shagari case, the MPN case that defined the meaning of 12 to 3rd, and a host of other cases, even in the criminal arena. So, of course, we have a very vibrant and robust judicial system, so the judgments are constantly coming.
The return of democratic rule in 1999 brought to the fore the vibrancy and courage of the judiciary, but then a disturbing dimension crept in. Allegations of political interference by political leaders and politically exposed persons started to trail the judiciary. Some take the view that this will become a worrying trend and will continue as long as the executive arm of government, both at the federal and state levels, continue to demonstrate an unwillingness to recognize and respect the financial independence of the judiciary, a situation which forces the heads of courts to often plead for the release of funds appropriated for the judiciary.
We are looking forward to that time when the judiciary, like the House of Assembly, we have autonomy financially.
The judiciary must truly be independent. Part of the independence of the judiciary will include that the judiciary must truly be independent and also now attracting funds to itself.
There has been a recent disturbing trend where courts of coordinate jurisdiction have given conflicting rulings in cases with similar facts, which has been attributed to the influence of interference of politicians. The case of the PDP leadership crisis and the Abia governorship seat this year exemplifies this point.
I believe that the position of the law is static and it doesn't change. And what is actually playing out is that some judges I find it difficult to distill very sensitive legal issues in some of the cases that are currently before them. And the lawyers also are not helping matters.
Going forward, many are optimistic that the leadership of the bar and the bench will work together to reform the judiciary. It is hoped that reforms will address the issue of corruption among judicial officers and will guarantee integrity and swiftly punish the unprofessional conduct of lawyers, especially the senior ones. Many also anticipate reforms that will cut down the high cost of litigation, delay in court proceedings, prison congestion, as well as reforms that will also shield the judiciary from political interference, so that justice will always be served on time to the plaintiff, the defendant, and the country.